Namaste, welcome to our class today. So, we were discussing regarding initiation of criminal cases. Okay. So, if we have to revise what we have done in a previous class, see, it was something where an offence has been committed, you may give complaint to the police, which is officially known as information with respect to cognizable offence or information with respect to non-cognizable offence, because you can also give complaint to the magistrate, right. So, this is how you trigger, you set the criminal law in motion. What do the police do? They investigate the case. The next step is investigation, but police will see whether this is a cognizable offence or whether this is a non-cognizable offence, right. The police will see whether this is a cognizable offence or whether this is a non-cognizable offence. If it is a cognizable offence, they can directly start with the investigation. They do not require any kind of permission from any magistrate. But if it is a non-cognizable offence, then they have to take the permission from the magistrate. They have to take the permission from the magistrate. When the magistrate gives permission, then they can start with the investigation. Okay. So, when the information is with respect to cognizable offence, that is said to be FIR. So, we have dealt with the FIR portion in a previous class. Okay. So, if we have to summarize what we learnt in FIR, FIR can be given orally or in writing or in electronic communication. If it is given electronically, the person has to sign within 3 days from the date of submitting the FIR, electronic communication, EFIR. This is one aspect, and FIR, with respect to FIR, if sexual offences have been committed, then it has to be recorded by a woman police officer or woman officer. The police officer has to, if it is given orally, they have to reduce into writing, and it has to be signed by the person, and the FIR copy must be given free of cost to the informant or the victim. This is one aspect. And if the victim of sexual offences is physically or mentally disabled, then their information has to be recorded in the residence or any place of their choice. Such procedure has to be videographed in the presence of interpreter or special educator. So, this is one aspect. And moreover, they have introduced the concept of zero FIR. When there is a zero FIR, it means that FIR can be registered anywhere, irrespective of the offence which has been committed. Wherever the offence could have been committed, but FIR can be registered at any place. Okay, this is one thing. And in the next aspect, we can see that with respect to preliminary enquiry, when it comes to preliminary enquiry, the person, if he gives information regarding offences which are punishable from 3 years to 7 years punishment, then police need not register the case immediately. They can conduct preliminary enquiry, and then if they wish, within 14 days they may proceed with the case, if there is a prima facie case. Okay. So, that is said to be preliminary enquiry, and if the officer in charge of the police station is not receiving the complaint, is not receiving the FIR, then it may be given to SP, Superintendent of Police, through writing by post. So, SP may conduct investigation, and even if this is not working, then the information can be given to the magistrate. So, if this is not working, then information can be given to the magistrate saying that please order the police to investigate a case. Okay, this is one aspect. Or you can directly give information to the magistrate without going through any of these mechanisms. You can directly inform the magistrate by way of procedure known as complaint proceedings, right. So, today we are going to learn what are the investigating powers of the police in cognizable offence, and what are the investigating powers of the police in the case of non-cognizable offence, and what is the meaning of the complaint. This we are going to learn today, right. So, when this is the case, let us understand. Okay, one more thing, the section, if I have to say regarding section, see we of BNSS, section 173, section 174 and section 175. These are the 3 sections which we are learning, and section 173 is something which we have already learnt, which is regarding information relating to cognizable offence, which is also known as FIR. And when information is given, the police have the investigating powers, right? So, the investigating powers have been given under section 175 regarding investigation as to cognizable offence, right. So, information is in section 173 and investigation is in section 175. Section 174, it speaks regarding information and investigation with respect to cognizable offence. It speaks both regarding information and investigation with respect to cognizable offence. Okay, that is one very important thing what we have to understand. Yes, so let us understand this, already we have learnt, and let us understand these two sections and then we can move on to the complaint. See here, this is section 175 or with respect to cognizable offence. We can understand different portion. See here they say it is the officer in charge of the police station, whenever they receive information regarding cognizable offence, they can start investigation, they can investigate the case without any order of the magistrate. They can start the investigation, okay. They do not require any magistrate's order, and even if the case is more serious, okay, considering the nature or gravity of the case, if the case is more serious, then what they can do, SP, Superintendent of Police, he may ask Deputy SP to investigate the case, okay. Superintendent of Police, SP may require Deputy SP to investigate the case. So, this is one aspect. See, sometimes what happens is, some police officers may not be having the power to investigate the case, because it is actually the officer in charge of the police station who has to conduct the investigation, but somehow if jurisdiction varies or some minor errors have taken place regarding the jurisdiction, if the police officer is not empowered. So, can we cancel the whole investigation? Should we cancel the whole proceeding? No, right. So, that is why they have stated that any proceeding of the police officer cannot be called in question at any stage, okay. So, no proceeding of the police officer at any stage can be called in question on the ground that officer was not empowered to investigate, okay. This is one aspect what we can say. And when it comes to magistrate power to order investigation, see, we have seen, right, if the officer in charge of the police station is not taking any action, if the superintendent of police is not taking any action, then what can we do? We can apply to the magistrate. So, when in that case, the magistrate must be having the power to take cognizance. So, when the magistrate receives the application along with the affidavit, so magistrate, what can he do? He can order investigation. That is very important, right. So, this is regarding cognizable case. See, understand, in cognizable cases, police can conduct investigation on their own. They do not require any permission from the magistrate. But even if they are not investigating the case, then what the aggrieved person has to do, what we common people have to do. So, we have to ask the magistrate. We can go and complain to the magistrate saying that, see magistrate, this person, police officer, even in spite of cognizable offence, he is not investigating the case. So, please order him to investigate the case. So, this is the application you are doing to the magistrate, right. So, here the magistrate is having the power to order investigation. The magistrate will not investigate, he will order the police to investigate. So, this is very important. Earlier it was said to be 156(3), but now this is said to be, or they are ordering the police to order investigation, right. Then comes public servant, when there is a complaint against a public servant. So, on receipt of complaint against a public servant, see, there is a public servant. A public servant, he would have conducted some official duties. With regard to that only, another person is complaining against this public servant and he has gone to the magistrate, okay. So, now magistrate will think, okay, the public servant of this person is complaining against the public servant. So, should I directly order investigation or should I take some precautionary measures? So, magistrate will think. So, BNSS has given extra 2 exceptions saying that magistrate can directly order investigation, but subject to 2 exceptions. He should follow 2 conditions. Before ordering investigation, the magistrate has to take report of whatever incident has taken place. He should receive report from superior officer of the public servant. Okay, that is one condition. And another condition, he has to hear the public servant, like whether, what about the situation, what has happened about the alleged incident. Regarding that, they have to see. Okay. So, here what you can understand is, on receipt of complaint against the public servant, the complaint is with regard to the public servant which is in the course of discharge of official duties. If it is in the course of discharge of official duties, in such cases magistrate can order investigation against that public servant. So, this is not about some personal offence of public servant. The offence is with regard to his official duties only. Okay. If it is some personal case, then this section is not applicable. Okay. He cannot ask superior officer to give report, but this is in the discharge of official duties. That is why the public servant, superior officer must give some report regarding the facts and circumstances of the case, what has happened. And also, so these are precautionary measures, because any person can complain against public servant if such broad provisions have been made. So, to curb that, okay, because public servant also must do duty. If they do duty, it may affect some person. See, for developmental work, some demolitions might be done. The other person may complain against his public servant for demolishing his unauthorized property, who knows. So, directly investigating is also not a proper mechanism. So, that is why the BNSS has inserted 2 conditions, 2 checks. Okay. So, it states that from the superior officer, he has to receive the complaint, and also after considering the assertions made by public servant as to situation that led to alleged incident. Okay. So, this is one such important thing what we say. So, we have learnt regarding in cognizable offence what is being done, and when it comes to non-cognizable offence, so it is regarding information and investigation both. So, okay, section 175. So, whenever there is information as to non-cognizable offence which has been given, then what will happen? When information is given to the officer in charge of the police station regarding commission of non-cognizable offence, whatever they have to make that entry in the book. Some book should be maintained with respect to non-cognizable offence. They have to entry that information in that book. Okay. So, daily they have to make the entry, and the daily reports should be sent for 15 days. Okay. Fortnightly they say. So, once in 15 days. So, daily they should not send it to the magistrate, but once in 15 days they should send, like right from January 1st to January 15th, whatever information has been received, all this information has to be sent to the magistrate. So, this is one new change which has been introduced. Earlier this was not there. So, why has this been introduced? Because the magistrate will be having, he will be, the police cannot do whatever, and like it is not police discretion, right. Police action needs to be checked by some other authority. That is why all those reports must be sent to the magistrate. So, this is one such information which they have to send it fortnightly. Fortnightly means once in 15 days. Fortnight means like what you call every 15 days, new moon, full moon, right. Fortnight means within 15 days, once in 15 days they say. So, this is one such important thing what we see. Then powers on receiving magistrate's order. See, one thing is very important. Here, the police officer shall not investigate non-cognizable case. Very, very important. That is the distinction what we were saying. In cognizable offence, the police can start investigation without magistrate's order, but here police officer cannot investigate non-cognizable case without the order of the magistrate. He needs to get the magistrate's order, magistrate permission to investigate non-cognizable case. Okay. And so when he receives magistrate's order, so magistrate, he will apply to the magistrate saying that this is a non-cognizable case, so please give me permission to conduct investigation. So magistrate will okay, he will say I will give the permission. So when he gets the permission, he gets the same power. Okay, if it would have been a cognizable case, how much power he had? He had many powers, right? He has the power to arrest, he had the power to conduct search, seize. So he had many powers. The same power he gets in this case also, in non-cognizable case also he gets. But this power he got, why did he get this power? Because the magistrate has given permission, right? So now he has the same power as officer in charge of the police station. How he exercises in cognizable case? The same power, okay, he gets in this non-cognizable cases also. Okay, I hope you have understood this. And the last subsection is very important. See, I will explain you with the help of example. Sometimes what happens is, see, there are many cases involved. I will say you about an incident. Okay, a person comes and says that in a house a thief came and he trespassed our house, and he bet my father with some sharp knife. Then he snatched our mobile phone, and he intimidated, he shouted us in very bad words, and he also said that if you say it to someone else, I will kill you. Like, he has intimidated, criminal intimidation he has done. And after that, he has run away with our property, all immovable property. He has caused disappearance of evidence. So many offences are involving, right? In one incident only we see many sections are being involved. When that is the case, see, some cases could be cognizable case, some could be non-cognizable, some cognizable, another could be non-cognizable. So what will the police do? What will he think? Should I investigate or not? Whether this is a cognizable case or whether it's a non-cognizable case. So what should he do? He has to conduct investigation about this investigation, right? But should he investigate directly, or should he take the permission of the magistrate and then conduct investigation? What should he do? So to solve the police problem, what the section has said that even if you have one cognizable case, okay, even if there is one cognizable case also, the entire case is said to be cognizable case. It means police get the power to conduct investigation in this case. Okay, even if there is one cognizable offence also, it is deemed to be a cognizable offence. Okay, that is what they have stated. So when case relates to two or more cognizable offence, okay, it could be cognizable or non-cognizable also, two or more offences, of which at least one is cognizable case. Even if one cognizable case is there, then it is said to be deemed cognizable case. Okay, I hope this is clear. Very important. So the ultimate summary of this is section 174. Yes, this is regarding with respect to information and investigation in respect to non-cognizable offences, where when information is received, it has to be maintained in a book, and fortnightly they have to send it to the magistrate, and they cannot investigate it directly. They have to take the permission from the magistrate, but when magistrate gives permission, they have the same power to conduct investigation as in cognizable cases. And in so many cases, out of so many cases, if there are two or more offences which involves cognizable also and non-cognizable offences also, even if we have one cognizable offence, then it is said to be deemed cognizable case only, deemed cognizable offence only. Okay, yes. So now let us understand, this was all about how the police had the power. Okay, this was a very introductory unit, because still we have different types of investigation, many things are there, but as of now what we are learning, how the criminal case is being how it is being started, how it is being commenced. with that aspect we have understood this. Now let us understand regarding the complaint. So complaint is something we have already learnt. This is defined under section 2H, and also complaints to magistrate you might have seen, okay, that is in BNSS chapter 16 we have certain sections. So when a complaint is received, what the magistrate will do, how he will examine the complainants, whether can he dismiss the complaint initially. So all these things are there which we learn at the unit 2 or unit 3, because that is regarding trial procedure, we will understand that. As I already said, this is only a introductory portion, right. So we can understand one by one. This is only a stage where how the criminal cases are being initiated, right. This is one such thing. Then let us understand what is a complaint. So when we understand what is a complaint, see, complaint is an allegation. It is an allegation which is made orally or in writing. Complaint is an allegation which is made orally or in writing, and it is done to the magistrate. Why are you making allegation to the magistrate? So that you want the magistrate to take some action. You want the magistrate to take some action, right? And what are you alleging? What are you complaining? You are telling magistrate that some offence has been occurred. I don't know which person has committed the offence. Or you can also say, okay, Mr. A has committed the offence. So whether you know the offender or not, whether he is known person or unknown person, but you know that offence has been committed, right. So with regard to the offence, you are making the allegation to the magistrate, here not the police, allegation to the magistrate, because you want the magistrate to take action. He may conduct inquiry, he may conduct a trial. So you want the magistrate to take some action, that is why what you are doing. So you are alleging, that allegation could be orally or also in writing also. This is said to be complaint, and very specifically they have stated this does not include police report. Police report is not included in this. Okay, what do you mean by police report? Police report is something where it is also called as charge sheet. Okay, charge sheet is after conducting the investigation, police will say, okay, Mr. A has committed the offence in this manner. They will submit it to the court, that is said to be charge sheet or challan. Okay, so police report cannot be considered to be the complaint, because even police are giving allegation. Police report is submitted to the magistrate only. That is why they are saying police report, okay, allegation to the magistrate is complaint, but if the police are submitting it, then that is not a complaint. But there is an exception, okay, there is an exception. See, it is said to be deemed complainant. As we have already seen, it is we can say that the police, what do? If they receive some information, they think that it is a very serious offence, cognizable offence, and they conduct investigation. But later they come to know that, okay, this is not a cognizable offence, this is a non-cognizable offence. They think like that. Okay. So if that is disclosed after investigation, if they disclose the commission of a non-cognizable offence, then what will happen? Police officer, whatever report he submits to the magistrate, that can be considered as a deemed complaint, because normally police report cannot be considered as a complaint. But if it discloses the commission of a non-cognizable offence, because he has not taken permission, he thought it as a cognizable offence and he proceeded with the investigation, but later he got to know that this is a non-cognizable offence. Can he stop the investigation? No, it is a waste of time, right? So he can conclude the investigation, he can submit the charge sheet to the magistrate also, but that will be considered as a complaint, deemed complaint. Okay. So the police officer who submits such report is said to be deemed complainant. Okay, very simple, this one we can say, this is said to be deemed complainant. Yes, so this is something what we have understood today. So if we have to summarize, we learnt about what are the investigating powers of a police in cognizable offence, what are the investigating powers of police in non-cognizable offence, and what do you mean by complaint. This is all what we learnt. In the next class, we will be learning about the rights of the arrested person, or regarding arrest, what happens in an arrest? Regarding this we will understand. Okay? Yes. So, thank you all of you for listening to the class. See you in my next video. Thank you. Take care and bye bye.